Welcome to the next episode of Call to the Bar, International Law Over Drinks, a series of casual conversations about current issues in international law, life in academia, and whatever else is on our mind. In these conversations, we are speaking off the cuff and without the benefit of footnotes, and nothing we say should be taken to have been thoroughly peer-reviewed. I'm your host, Dr. Juliette McIntyre, Senior Lecturer in Law at the University of South Australia. And today I get to interview two of my favourite scholars about one of my favourite topics. Podcasting hosting perks are real. With me today is Mike Becker, Assistant Professor of International Human Rights Law at Trinity College Dublin, Honorary Procedure Goblin, and the person I am most scared of disagreeing with online because it would probably definitely mean I'm wrong about something. Also joining me tonight is Dr. Kyra Wigard, Assistant Professor at the Willem Pompe Institute for Criminal Law and Criminology at Utrecht University and data diving expert. Kyra's thesis was titled Tracing Legal Traditions in the Decision-Making of International Judges, Evidence from the ICJ and the ICC. She knows more about judges than just about anyone. And judges is what or who we are going to be talking about tonight, from politics to plagiarism and everything in between. But of course, first question, what's your drink?
Right. Well, first, Juliet, thank you so much for having me on the podcast. I've been listening for these many months and was just waiting to be invited to join you for this. So, despite the fact that for me in Ireland, where I'm joining you from, it's completely the wrong time of day, I wanted to choose something appropriate for this occasion. So I am enjoying here a fine Irish whiskey, which is designed, I think, especially for international legal scholars or maybe PhD students because it goes by the name Writer's Tears. And I have the copper pot variety here, which according to the website is matured in flame-charred American oak bourbon casks. I just wanted to include that bit. And not only is this an Irish whiskey, but best of all, it's a whiskey produced here in County Carlow, where I am based, in the foothills of Mount Leinster in the southeast of Ireland.
Sounds delicious. I feel like I've heard of this whiskey if I haven't actually tried it, but I will definitely have to try this at some point. Kyra, how about you?
Drink is much less interesting. Indeed, it's 11:40 here in The Hague, so I am having a coffee.
Fair enough. Look, we love coffee on this podcast. We are very supportive of the caffeinated beverages. But I'm actually joining Mike in a whiskey and also keeping it local today. I have a Fleurieu distillery, so the beautiful Fleurieu Peninsula, which is about an hour south of Adelaide. And this is the last drop of their first batch. I just finished the bottle off today. So cheers and good tidings to all. But look, let's move on to the subject for today. And let's begin with the most recent hot topic, which is plagiarism. Because it was recently reported on social media that the acting president of the International Court of Justice, Julia Sebutinde, had plagiarized some of her opinion in the legal consequences arising from the policies and practices of Israel in the OPT advisory opinion. She copied and pasted from an article by Douglas Feith and the Jewish Virtual Library without attribution, and in fact, possibly more sources, but we might get onto that. Now, look, we can all agree plagiarism is bad, but is this incident more serious than just forgetting to footnote? Mike, what's your view?
Right. So I think it's serious, but at the same time, there's a nuance here that I think has gotten a little bit lost in some of the public outcry or some of the media coverage of what's happened here exactly. So, our starting point can just be, well, what's plagiarism? And I looked up one of any number of definitions, but they all are pretty much the same. So I saw that the University of Oxford, I mean, what better authority could we have than that? The University of Oxford says plagiarism is presenting work or ideas from another source as your own, with or without consent of the original author. So fairly, that's fair enough. And I think the question is not really here whether there is plagiarism in what then Vice President Sebutinde put in her dissenting opinion. In the advisory opinion, it seems pretty clear that some portions of it and probably substantial portions of the opinion meet the definition of plagiarism. But what I thought was interesting here is whether some forms of plagiarism are less problematic or are more acceptable than others, depending on context or situation. And I started thinking about this because after you and I, Juliet, commented on this in some articles that were published online, I got a lot of blowback on social media from people saying things like, look, there's no such thing as judicial plagiarism. Courts can't plagiarize. If you're a lawyer who isn't plagiarizing, you're committing legal malpractice and this sort of stuff. And while I wouldn't put it in those terms, I wouldn't quite say things that way. I understood where these comments were coming from to some extent. Having been in practice as a lawyer myself, having worked for judges not only at the ICJ, but also in federal court in the US, there's a difference, I think, between what we could maybe describe as litigation plagiarism or judicial plagiarism, like we have in this case, versus academic plagiarism that those of us who are academics for a living take very, very seriously, or of course, plagiarism in journalism or in a literary setting. I think in litigation, and if people are listening to this who are practicing lawyers, I think it's pretty fair to say that lawyers recycle material pretty frequently. You might use a summary of the applicable law or a certain line of argument that was in another brief in another case, and you may or may not have been the person who wrote that. Maybe it was a colleague within the same firm, or maybe it was opposing counsel in some other case you were in, and you thought, oh, that's actually a great argument. That's a great way to put that point. And now it actually fits what I'm doing. So I'm just going to lift it and use it. And I don't really think that that's considered problematic, or we wouldn't really think of that as, I mean, it meets the definition of plagiarism, but it's not really a problematic kind of plagiarism necessarily. I looked this up, or I was doing a bit of research on this, and I saw that there are people who've written about this and talk about how litigation is different. I'm quoting here to be careful and based on what this conversation is about. So an article by people named Schatz and McGrath from something called California Litigation, so probably a bar publication in California in 2013. Their article was called Beg, Borrow, Steal, Plagiarism versus Copying in Legal Writing. And they said litigation's different, with far more room for borrowing ideas and writings, but be warned that significant unattributed copying may cross the line. Be forthright, give the cite. I think that's basically right. There's a certain judgment call. You know, if you're really going beyond just taking bits and pieces here and there, it can become problematic. Now, courts and judges, I think in some instances also recycle text and don't attribute to their sources, especially maybe when describing uncontested facts or taking judicial notice of things. That's not really that problematic. It's maybe not ideal. Judgments might also take up arguments or some kind of conceptual framework that a scholar, an academic, has put forward in their work. And they might do so without acknowledging where it came from. The ICJ, for example, never cites secondary literature. It doesn't cite scholarship in the judgments. We see it in separate opinions and dissenting opinions, but not in the judgments. But I think many academics would be very happy, would be delighted to see some novel theory that they presented in their article in EGIL or wherever else being picked up and applied by the ICJ or some other international court, whether or not they get the credit. Of course, it's nicer to get the credit, but if you care about your ideas, it's great to see those ideas being put into practice. So I don't think the issue is as black and white as maybe comes across here. All of that said, I do think that what we see here in Sebutinde's opinion is problematic for a few reasons, even if we accept that some amount of judicial borrowing can be acceptable in certain circumstances.
Yeah, so I mean, there was a case in Australia not that long ago where a judge was penalised because they lifted huge chunks from one of the parties' submissions and just copied and pasted them into the judgment. And a lot of people were like, yeah, judges can't plagiarize. This is just what judges do. But the problem was, and the reason that the judge got penalized was that it had indicated a lack of attention, essentially, to the question of the judgment. The judge wasn't demonstrating that they had really applied their mind to the questions before them, and they were just wholeheartedly adopting one party's submissions, but without giving any attribution to that party, without indicating that they agreed with that party's submissions, just making it as though it was like this total fait accompli. And so that was considered too much, for at least for domestic judges in the federal court system here in Australia. But yeah, Kyra, I mean, what are your views on the situation with the Sebutinde so-called plagiarism?
One element that struck me, and I haven't seen too much about it, is of course this was in her individual opinion, no? And she is if I'm not mistaken, she was the only judge to issue a dissenting opinion in this advisory opinion. And so it was inevitable that the reasoning that she would put forth in it would be scrutinized. And so I think, on the one hand, the fact that it's signed off by the individual judge rather than the court as a whole, it's not part of the judgment, the advisory opinion as such, but it's the individual opinion. For me, that adds another layer to how problematic this is. And I do have to agree, I have never been struck by the abundance of footnotes, no, at the ICJ, either in judgments or in individual opinions, but definitely in this case, that for me, it adds to how problematic this is.
Yeah, Mike.
Yeah, yeah. I mean, I think part of the issue here is that, I mean, so some people might look at this and say, well, what rule has she violated? How is this improper in any formal sense? And I mean, the answer to that is, yeah, there aren't formal rules here, but this type of thing is really governed by professional norms. And it does go not only to that point about, well, plagiarism, the rules on plagiarism are meant to ensure that you give credit to other people's ideas. It's not only about that, it's also about showing that your own arguments are sound. And so we disclose our sources normally because our sources bolster the authority of what we're saying. And when I talk to students about how important it is to adopt good citation practices, it's not only about, well, you can't steal other people's ideas. I also need to know where you're getting this from. What's the basis for this assertion that you're making? And are you getting this idea from a reliable source? So one problem here, I think, with Sebutínde's opinion is that it raises that big question. Well, why not identify these sources? It was apparent from it to anyone reading her opinion back in July, because for those who don't know, about half of her opinion is this long kind of historical account of uh, the situation in Palestine. And her starting point is that, well, the court's own opinion doesn't properly go into that history and therefore adopts a kind of one-sided historical narrative that doesn't provide enough context for the court to properly answer these questions. And so she's trying to provide a counterbalance. That's how she presents it anyway. Um, but in that case, why not actually explain to people where you are getting your assessment of this history from? And so when you don't disclose sources, that raises some big questions. Yes, it might just be inadvertent. Maybe it's just, for lack of a better word, kind of shoddy work. But on the other hand, we might think, well, actually, there might have been an understanding here that these aren't the types of sources that bolster the authority of what you're saying. They're actually the types of sources that would undermine the credibility of the historical narrative you're presenting. Because people might say, well, actually, oh, that's where this is coming from. These are hyper-partisan sources of information. This is not the work of responsible historians, or this isn't a history that's been written kind of following the best practices that a historian might follow. This is a highly politicized uh, version of the history, which is now being adopted kind of wholesale and presented for a broader readership without any trace of where it's come from, but now giving it this kind of judicial primatur of legitimacy. So that's one problem. And the other problem that I'd mentioned before is that whenever judges rely on materials outside of the record, so things that parties didn't submit, well, that means that other participants in a case didn't have an opportunity to challenge that material.
Mm-hmm.
So it's also problematic to me. That's not directly a plagiarism question, but that is a question about, well, not disclosing the sources. And these sources turn out to be things, I think for the most part anyway, that were not put into the record by anyone else. And so haven't undergone that extra level of scrutiny that I think is meant to weed out stuff that simply shouldn't be relied on. So there's some other problems with what we've seen happen here.
Yeah. And does it reflect poorly on the court as an institution as well? Because I mean, a lot of people on social media were shouting, oh, it's corruption. And I'm like, no, it's not. But there is a legitimacy question perhaps here, isn't there? Because especially given that she's currently in the acting president role, what this does is create a little bit of suspicion perhaps around, at the very least, the quality of the judgments that might be being issued by certainly not all of the judges. Like, let's be very clear about that. Like, there are some extraordinarily brilliant people on the bench, but some of them, and certainly her being in this acting president role where she has the casting vote in the event of a tie. Let's say there's a tie judgment in the Gaza case, South Africa, Israel, and her deciding vote is the one that swings it in one direction. That's going to be problematic for the institution and trust in the institution. Is it not, Kyra?
I absolutely think so. Yes, it's one of the most important things of the ICJ in general, but also of international courts in general. The international judges that are serving at these international courts, we only have few criteria, no? But one of the criteria is they have to be of high moral character. And it's because we want to ensure that when it comes to both factual, but also when it comes to perception, there are no issues, or at least as few as possible. Indeed, the reality that Judge Sebutinde has become the acting president now is a very unfortunate coincidence, I would say, which is not good for the perception of the ICJ in general.
Yeah. So, I mean, Mike, sorry, go on.
Yeah, I just say, I mean, I agree. It certainly reflects poorly on Judge Sebutinde or acting President Sebutinde, but I think it does reflect poorly on the court as a whole through no fault of its own. It ends up feeding into this whole episode feeds into the narrative that judging is just a kind of barely veiled political exercise, which I think is a harmful narrative and a narrative that doesn't capture the reality of how things actually work. So it's not a good look. And I'd also say, some people said, well, the focus, what I don't like about this whole thing is that some people are jumping on it because they really don't like Judge Sebutinde's positions, and in the South Africa versus Israel case and in the advisory opinion case. And so that's part of why this is getting so much attention. And I just emphasize that this to me would be very problematic no matter who on the court was operating in this way. And if people want to dig through past separate and dissenting opinions to try to identify whether this is a more endemic problem, then it doesn't seem to me to be a problem like that. But if it turns out that judges are doing this more often than we realize, that's not good. And for the reasons Kyra is saying, it's not good because it undermines the overall credibility and legitimacy of the institution.
Well, there you go, Kyra. That's a new project for your brilliant data analysis skills. How much plagiarism really happens at the court. But look, I'm going to move the topic on because we've mentioned that Sebutinde is in this role of acting president. And the only reason that she's in this role is because of another unusual event at the ICJ. And Mike, you were just talking about politics, and this is the point of intersection. Nawaf Salam, who was the former president of the International Court of Justice, has just been elected to the position of Prime Minister of Lebanon. And so Salam was sitting as president of the ICJ at the same time as he was up for election or appointment. And he retired from his position as a judge when he got this role as prime minister and not before. And so, Kyra, I wanted to ask you, is this common for judges to move into political positions? And does this speak to the question of the judges' independence at all, if they're also going to be sitting in these political kinds of roles?
Well, it's not common, not at all, I would say. In general, becoming an ICJ judge is not something one does at an early stage or mid-level of their career. No, it's very much one of the highest achievable options in one's career. And this has been reflected, for example, in the average age of ICJ judges as well, no? One important factor there as well is that judges can be re-elected after their 9-year term. So that means that once someone becomes an ICJ judge, there is a real possibility or opportunity for them to stay at the court for a longer period of time. I think I didn't check this, but I think Judge Tomka is on his third term. I think he's been there since the early 2000s, more or less. And so it is really rare for judges to move on to a high profile political position. Of course, there were previous moments already during Judge Salam's tenure that it appeared like a real possibility that he would become Prime Minister of Lebanon. But if I'm not mistaken, he was not elected eventually in those one or two earlier moments. But now he is, and again, I did not do a very thorough checking, but if I'm not mistaken, the second judge to become head of government after Judge Al-Qassam became Prime Minister of Jordan and left the court for that. But he was not the president at the time. So this is the first time. But again, perhaps one of our listeners can clarify or prove us wrong on this. But if I'm not mistaken, this is the first time that an acting ICJ president leaves their position, resigns during the presidency to become prime minister of their country, head of government at least. There's a very useful post on Ijil Talk by Dapo Akande, himself now nominated to become a judge at the ICJ next year, at the elections next year, where he does find that a couple of judges of the ICJ have gone on to be foreign ministers of their country, for example. But really, head of government, head of state, during their tenure is a very, very rare thing. On the resignation in general, I would say it's again something that puts the court very much front and center of political debates, and it raises a lot of questions. But again, given that this was not the first time that it was a real possibility that Judge Salam would become Prime Minister of Lebanon, it also wasn't such a surprise, I would say. But I'm curious to hear your thoughts.
I just wanted to point out, Kyra's absolutely right that Judge Al-Qassani in the somewhat recent past left the court midway through his term to become Prime Minister of Jordan for all of about 6.5 months.
Yes.
So that, I'm not sure that was a great trade-off, but sure, things happen. And then to Kyra's other point, yeah, I mean, there's only, in my research on this, there was only one instance ever where somebody who was sitting on the court and was in the role of the president of the court left, or their term ended prematurely, and that wasn't because of resignation, but because of death. In the case of Sir Humphrey Waldock, this is back in 1981. He passed away while serving as ICJ president. So at the time, the vice president, Judge Elias, stepped in as acting president and then was subsequently elected to be president of the court at the next normal time for those internal elections. So it seems to me like the issue around Salam is not only, so I mean, my general view on this is that it's not a good look for the court, for judges to kind of move seamlessly between the bench and political office, whether as kind of an elected politician or simply even entering into government service. Again, because it reinforces this idea that judges are simply political actors wearing black robes, which again, I would emphasize in my view is not normally the case, but it is this persistent narrative. And so what has happened with Salam here reinforces that narrative. And Salam's election as president was always a bit awkward. I mean, it's definitely been awkward that he's been president of the court while these cases relating to Israel have been heard. I don't think there's any question about that. And it's because of his past positions, because before he was elected as a judge to the court, he was Lebanon's ambassador at the UN in New York, and therefore had made lots of statements representing Lebanon in connection with Israel. So this has been awkward all along. But I take it, Juliette, that maybe the issue you wanted to talk about in particular was or certain statements that Salam made immediately upon his resignation from the court. Is that right?
Yeah, well, so for those who don't know, Salam referred to Israel as the enemy in statements that were made, I believe, literally the same day that he retired from the court. And I mean, it's one thing to it would be one problem for at least a lack of perception of independence if Lebanon had been involved in cases that he was deciding. But that is not necessarily significantly more of a problem than it is already for judges who are deciding cases in respect of their home state. But these comments, well, that's some pretty strong language. Do we think that's bad? Seems pretty bad.
Well, it's again, like Mike said, no, it doesn't look good. And that already, and I feel that that is something when it comes to the ICJ, but to also for other international courts for that matter. I think when it doesn't look good, when it comes to judicial decision making, it means you're already sort of losing, because the perception of independence, of impartiality is integral to whatever you are doing as an international court. And just the fact that these questions are now being asked means that it's not good for the court. And as we both already said, this is not something that happens fairly regularly. No, it's an extraordinary casual vacancy that came about. This is, in that sense, unlike also something we have seen before. So it does make sense that it's not being dealt with in the most smooth or seamless manner. I think all of that we can understand, but at the same time, knowing the ongoing cases of the court and knowing the political climate, this is something that could have been thought about more carefully, I would say. Yes, at the very least.
Yeah, and we have another former president who made some controversial comments about the Israel case as well. President Donahue, when she retired and stepped down, appeared on television and, explained, as it were, the judgment for the viewing public. But that explanation doesn't necessarily reflect the views of the entire bench. But yeah, Mike, what's your take on this situation? Should judges make these kinds of comments?
In Salam's case, it does seem like this choice of words was maybe not the best choice of words, but at the same time, I mean, he is in this new position. He, I'm sure, has reasons for saying what he's going to say, and I think many commentators seem to think this is a great appointment for Lebanon, and this is a great appointment in terms of moving towards a more peaceful situation. He was not Hezbollah's choice. I mean, there's lots of, we have to separate out kind of our hand-wringing about what's going on at the ICJ, maybe from the bigger picture. But yeah, you would have liked to think that somebody with a judicial temperament, even stepping into this very delicate political role, would have been very, very careful, especially in those early moments, and that doesn't seem to have been the case here. In terms of this general question of kind of judges commenting or speaking, so when judges are actually on the bench, I think it's pretty important for judges to be involved in what we could call judicial outreach. So a lot of judges will give lectures, give talks, meet with visiting groups of students, and so forth. Occasionally, and some judges, especially judges who came from an academic background, might continue publishing, or judges occasionally appear as a guest on a prominent blog or something like that. I think that's all fine. And of course, that's also fine for judges in their post-judicial lives as well. But you expect judges to exercise a lot of care and discretion. And judges normally don't reveal things happening in the confidential setting of the deliberations chamber and all of that. I mean, on Judge Donahue, the point about Judge Donahue, yes, she gave this interview on the BBC Hard Talk program talking about provisional measures in South Africa versus Israel. this was immediately very controversial. In part, in my own view on that is that it became controversial because what she said was, in my view, misinterpreted in lots of different quarters, because I think the actual words that she uses track what the ICJ's January order in that case had to say. But it obviously um, was interpreted by different people coming at that issue in different ways. And if a judge is going to comment on a decision that they were involved in, of course, I think they should take into account that risk, that it's so easy for any given word or phrase to be slightly misinterpreted and things to spin out of control very quickly. And maybe that counsels in favor of just not doing this. I
Yeah.
don't know. That's a tough one.
Well, this actually leads quite nicely into the next issue I wanted to raise, because in this age of social media and 24-hour news cycles, yeah, things will get blown out of proportion and misinterpreted either willfully or accidentally very easily. The world is this huge kind of melting pot of views and opinions, and some better informed than others. And personally, I learned about Salam's appointment through Twitter, in particular from a tweet from Bogdan Orescu, a current judge at the ICJ, the only ICJ judge that we know of that has a Twitter account. There may be others lurking behind anonymous accounts. We don't have that information. So, leading on to this question, it's one thing to make comments after your retirement, which both Salam and Donoghue technically did. But should judges have social media accounts? Do their posts and do their likes on things risk giving rise to perceptions of bias? Just how careful do judges need to be here? Do they need to be in a special chamber where they're locked away from the rest of the world, thus giving rise to accusations of being in an ivory tower and being out of touch? Or is being part of the, current world of interconnectedness on social media just going to lead to trouble? Kyra, what's your view?
Well, I would say judges, like everyone else, have a right to self-expression, no? And I would also say social media is such an important part, a major part of modern communication. But I would say for judges, what they post, what they like, even what they follow, whose accounts they follow, can be scrutinized and will be scrutinized in ways that might affect, again, perceptions of their impartiality. And I think one of the challenges there is a single like can be interpreted as an endorsement, even if you say that it's not an endorsement. And if you tweet about case A, but not about case B, what does that mean? Do you find case A more interesting or more legally sound? Do you not like the litigants in case B? Again, it allows for all kinds of discussions which are not at all relevant to the judicial function. So I would say, although it probably doesn't come from a bad place, if you hold such an important position, I do think you really have to keep in mind that algorithms and everything, they don't care about judicial ethics. You should care about judicial ethics. And in that sense, I would really be very hesitant in that. Of course, you do see that a lot of judicial candidates, again, now already leading up to the elections next year, there are Twitter accounts, social media accounts created for the candidates. Sometimes it is their old accounts that are being transformed into this. So it's very much part of international law. So I think we shouldn't say, well, it's bad all around. It cannot happen, because it is happening. But you do see that then after the elections are over, the accounts are either discontinued or just no longer used. So that's what I would say about that.
Mike, do you know of any
I think
secret judges on Twitter?
while you were talking, I was looking up to see if there was somebody who still had an account, but it seems to no longer be there. So no, no. I have a unequivocal view on this. I think judges should absolutely retire their social media accounts when they take up the position on the bench. There is no significant value in tweeting out
Yeah. I mean, I've got to admit, like, I'm nosy, right? So I enjoy seeing those little tidbits of judicial life, but I think you're right on balance. The risk is too great. And it's one thing to have a campaign that's deliberately targeted at building awareness for the purposes of a vote. Because of course, I mean, foreign ministries are on Twitter, governments are on Twitter. The individuals who operate in those offices are on Twitter and social media. And so it makes sense to have your campaign run through these platforms, in addition to the old-fashioned brochures handing out handshakes and stuff at UN meetings. It's the way the world operates nowadays, building awareness of who you are and your capacity for the role. But yeah, once you're in the role, it's quite a different story. And it does really all come back to questions of protecting the institution, at least in my view, because you're there as an individual to judge, to do the act of judging and making judgment, right? I mean, that's your job. It is to apply your mind to these questions and do the best job you can to resolve the dispute between A and B, or decide what it is that this interpretation means. But you're also part of this bigger structure. And if you do or say things that lead to this structure being the legitimacy of this structure being whittled away, well, then you're doing yourself a disservice, you're doing your co-judges a disservice, and you're ultimately doing international justice a disservice. And I think that's the thing that alarmed me about Salam's comments, for example, that even if he's completely right in everything that he said in the South Africa-Israel case, even if his decision is the most correct in law, once he's said that, well, it doesn't matter anymore, right? Like, there is plenty of material for people who disagree with that to argue back, because they can just say he was biased, it was not independent. And as you said, Kyra, the more that judges are operating in these platforms, the more opportunities there are for those kind of criticisms to come to light. Oh, you follow this particular charity or this particular organization, therefore you're not unbiased in this decision. And that just is hugely problematic, because I have a favorite quote from David Luban, which is that international courts bootstrap them into legitimacy by the quality of the justice that they deliver. Apologies to David if I've massacred that quote, but I'm pretty sure that's what it says. And that's exactly right. Like, they don't have any other enforcement mechanism other than being convincing, and that convincingness depends on their legitimacy and their authority. So you've heard it here first, folks. Call to the Bar says, judges, get off social media. But look, this leads into our final official topic, which is, perhaps one explanation for these shenanigans, for want of a better word, is that there is a lack of formal guidance for judges at the International Court of Justice about what is and isn't allowed. There are requirements for judicial appointment, including, as Kyra mentioned earlier, that the person be of high moral character, and they also have to possess the qualifications for judicial appointment in their home country. Judges are also barred from sitting on cases in which they were acting as counsel, which was a massive problem for James Crawford when he was appointed, because he was counsel in pretty much everything. But besides this, there's nothing. As far as the public is aware, I mean, there might be secret internal documents, but it seems rather more like it's just practices and customs that you would expect from judges. There are no formal rules governing what judges can and cannot do. Whereas the European Court of Human Rights very recently announced that it will create an ethics council to advise the court's president on questions of judicial ethics. And so what do you think? Would this model be a good idea for the ICJ?
I think in general, everything that we've been discussing today shows that judicial ethics are very much both fundamental to the legitimacy of the court, but also very much at the forefront of the decision making. And it's in that sense quite extraordinary that the ICJ does not already have something like this, because I did a quick search and most other international courts either have something in place. The ICC has the Code of Judicial Ethics. There was a recent initiatives across all international criminal courts and tribunals, Ethica, to also address some of these issues, which, if I'm not mistaken, was signed by all of the presidents of the different tribunals to already endorse these initiatives. It also mentions a few things on social media, by the way. And it is in that sense quite interesting that we don't have anything like this yet at the ICJ. So whatever model would work best, I find quite difficult to answer, but that these recent developments can perhaps spur or start a discussion on some kind of body or resolution, I think wouldn't be a bad idea at all.
I just want to highlight so there is one example, I think, of the ICJ responding to concerns about judicial ethics and actually doing something about it. So very close watchers of the court or ICJ fanatics might remember that back in 2018, when Judge Youssef was the president, in his annual speech to the UN General Assembly, he took up the issue that had become kind of a hot topic at the time about double hatting. So this phenomenon of ICJ judges also sitting as arbitrators, whether in interstate arbitrations or investor state arbitration or just pure international commercial arbitration. And this was seen as problematic for any number of reasons. Problematic if you're involved in an arbitration that involves a state that might also be a state involved in a case at the ICJ, but also problematic just because states might become parties to a case at the ICJ while an arbitration is pending. Also, the concern about judges, seeking out appointments, and also concerns about judges essentially spending too much time on work other than their work for the court. So the court responded to those concerns and put in place some restrictions on that. So it doesn't completely rule out ICJ judges participating as arbitrators, but it, in principle at least, places pretty considerable restrictions on how often or when or to what extent judges can do so. So I point that out just to say this demonstrates, I think, that the ICJ is not oblivious to these types of concerns and actually has the capacity through its internal practices to come up with workable rules designed to address things like that. So that's one point. The other point is I just wanted to mention, this also is kind of in light of some of what I saw on social media in response to the plagiarism episode, is the court does have a mechanism for, in principle, in theory, there's a way that you could remove a judge who has done something extremely improper. So Article 18 of the ICJ statute allows for the dismissal of a judge, but it has to be based on the unanimous vote by all other judges sitting on the court. And there's a procedure in place if you were to kind of trigger this Article 18 procedure that resembles kind of like a disciplinary hearing where the judge accused of wrongdoing would have an opportunity to defend their conduct and so forth. Needless to say, there's no record of this procedure ever having been triggered in the history of the court, let alone actually brought to a point where a judge was dismissed on Article 18 grounds, although people have commented that in a situation like this, the situation might become so uncomfortable that a judge would simply resign anyway, because it would be very difficult for them to continue to function within the court if a substantial number of their colleagues thought something was so serious as to merit dismissal. But I point this out just to say that this is another kind of safeguard in the case of some severe ethical lapse, although we might say that the threshold to ever actually take advantage or use that mechanism is far too high. I saw that just by point of comparison at the ICC, for example, there's a totally different mechanism. A judge could actually be removed, as I understand it, by the state's parties. But it's a vote of 2/3 members of the state's parties. So there are alternative models out there, and I'm not suggesting that would be a good model for the ICJ either. But I guess this goes to say there are lots of ways that this could be handled, and it isn't kind of inevitable that you can't have any kind of system in place.
And look, it really, again, comes down to reputation, doesn't it? Because the benefit of publishing an ethical code of conduct, it may well be the case, it probably is the case, that the judges are already doing all of the things that would be in that code of conduct. The benefit would be a question of public perception, knowing that the judges are following these rules, not having it hidden behind a veil of just, well, they're judges and therefore we expect them to do the right thing. And having some, the knowledge that there are standards and those standards have been articulated and that the judges will be following those and that there would potentially be consequences were they not to follow them would perhaps do a lot to restore confidence in the decisions of the court. Have we just maybe moved past a point where we look at these institutions and they're complete black boxes and we just have to trust everything that comes out of them? Are we now in a space where courts need to justify and explain themselves further? I mean, perhaps that's all these ethical codes do. They don't change anything. They just make it clear that judges are, in fact, behaving themselves.
Yeah, and it's also not a magic. I think having a code of ethics or something like that is not going to then... None of the code of ethics that I've seen have a provision on plagiarism, for example. No? So even if you are looking now, okay, this has happened. How are we going to solve it? We need a new rule. We need something like this. It is also just not how it works. No? So is it good to perhaps spell out a few of these things a little bit in more detail? Like, as Mike said, indeed, President Yusuf really also already made huge steps in, I would say. I think it would be helpful, absolutely. But should we be distracted now and then whenever something comes out, check if there's something on plagiarism? No, I think these are not necessarily the main issues, no? And even this, some of the recent developments we can read into already. The statute in the practice that these things are just not done. And I don't know if a new code of ethics would solve the issue, so to speak.
Yeah, I think a code of ethics I'm not saying it would be a bad idea, but it might be viewed as largely a kind of performative exercise. Because I think you're right, Juliette, that for the most part, judges, ICJ judges at other international courts and tribunals, probably in the vast majority of situations that might raise ethical issues, do the right thing because the credibility of their position and the credibility of their institutions depends on it. So I think the value of a kind of ethics statement would come down to, are there real areas of practice where it's not clear what's ethical or not? And then a code of ethics could say, okay, we're going to make a decision here that this type of conduct is okay or that type of practice is not okay. That could be useful, but something that kind of restates the principle that judicial writings should provide proper support for their assertions. So kind of a nod to following good citation practices and not plagiarizing. I don't know that it would actually change anything because there's probably a degree of license there in terms of, well, I'm just taking judicial notice. I'm not, a judicial opinion doesn't have to be written in the way that a law review article is written and so forth. I don't know. That seems like a degree of regulatory oversight that probably isn't practical.
Fair enough. Well, okay, so we're getting close to an hour of chatting, which is usually about when we wrap it up. But before we go, we have 3 very important questions to ask, and these are always the questions that our guests seem to be the most terrified of. But we always ask these questions, and because you're both first-time guests, you both get to answer all 3. So, Mike, I'm going to start with you. And the 3 questions are, of course, what recommendations do you have for anyone who would like to know more about what we've discussed today? What are you working on at the moment? And what is your current escape route? What are you doing, reading, or viewing that takes your mind off international law?
Right. Okay. I only realized that these questions were going to be put to me 5 minutes before we started. So here goes. I mean, there's loads of material out there about judicial ethics, whether in the international context or not. So I'm not going to point people to that. But what actually came to mind for me, because I think, so my recommendation here is an old but not very old book. This is Glider Hernandez's. Can I call it a classic text? I don't know. Glider would probably
Yeah,
like that. The
It's a classic. It's a
International Court of
classic in
he
our
Justice
would
and the
world.
like
That
that.
will do.
Judicial the International Court of Justice and the Judicial Function, which I think is a wonderful book about the ICJ and focuses the mind on this question of what is the judicial function? How do we understand it? And I wanted to suggest that because I think a lot of these questions and issues that we've talked about today about ethical concerns also relate back to, well, what do we expect of the court? What are we ultimately expecting it to do? So it's not directly a text about judicial ethics, but I think it actually should inform the answers to a lot of the types of questions that we were talking about today. What am I working on at the moment? Lots of things. Many of them are top secret, but I hopefully will see the light of day very soon. I've been working on some listeners might know that I sometimes write or talk about fact-finding bodies and commissions of inquiry. So I have something in the works about the way that the International Court of Justice in particular makes use of or relies on the outputs of fact-finding bodies, especially in the context of provisional measures, but not only. So, and then also going back to, we mentioned Judge Donohue's BBC interview. I'm also working on something relating to everyone's favorite topic, the plausibility standard in provisional measures. And what's my current escape route? What do I do to take my mind off of international law? I wish I knew, Juliette. Please help me. Please help me out of this vortex that I find myself in. I'm very lucky to have two wonderful children, two girls. So my daughters definitely help pull me out of the dark vortex of international law that I find myself pulled into all the time.
There's always more writer's tears if you really need to like just wipe the slate clean. But
Or that.
I feel like I should say, drink responsibly or something as well. I don't know. We don't have any sponsors at this point, so we're probably safe. But Kyra, same three questions for you. What do you have any recommendations? What are you working on at the moment? And what is your current escape route?
So when it comes to recommendations, I really echo what Mike just said. I think Glider's book is fantastic. And it's also great to just go back to whenever I feel I need to take a step back and just look at the quote a bit more in general. Another recommendation, perhaps to change the whole Tinder thing into something more positive, is to read the individual opinions. Because usually there's fascinating stuff in there. It's something I started doing for my PhD, and it's almost every time that there's an order or a judgment, it's my favorite part because you can really, depending on the judge, you can really sort of see their own philosophy in it. It's something that I really enjoy a lot, and I really recommend if you want to get a full picture of whatever kind of judgment there is. I mean, there's always at least around 15 judges, and there's only one decision, and it's fascinating to read a bit more about what each individual judge, at least whenever they feel the need to speak out individually, what then they decide to speak out about. So that is definitely a recommendation I would have. I'm working on not so many top secret things, unfortunately, but there's so much going on, not just at the ICJ, but also at the ICC, the other institution I work on a lot. And so much is unfolding before our eyes, even. So there's a lot that I work on that concerns the institutional frameworks of both institutions, what it is that judges try to do to make their decision-making process more coherent, what kind of changes we see. So those are the main things that I'm working on. And what I do to distract myself, well, I recently moved house, so now I live a bit closer to the beach in The Hague. And although it's not summer like with you in Australia, Juliet, even in winter, it is really nice to be able to walk to the beach. And I have to admit, I can't wait for spring and summer also for those purposes. But that is one of my favorite things to do, to get my mind off all the things that have now become also mainstream media news that we do. So it's very interesting. Yes.
Indeed. Yes. I think those of us who work in court watching in to one degree or another are going to be very, very busy for the foreseeable future. Well, that wraps things up. Thank you, Mike, and thank you, Kyra, so much for joining us on Call to the Bar. It's been absolutely terrific, and I hope we can have you on as guests again sometime in the near future. Thank you so much.
Thank you
For
so
having
much,
us.
Juliette.